Hi, I'm Tony Teesdale from Teesdale Associates. I've been an innovator in the employment relations field for over 40 years and consulting for 30. There's a lot of change in the employment relations field and low business confidence. We've got a lot to talk about. It's important to keep things in perspective. We've got a lot to get through, so let's get started. Okay, the first issue I want to talk about is the Employment Relations Amendment Bill, and the reason for that is this is the one that is most imminent. But interestingly enough, progress has been a bit slow. I think that New Zealand First has some issues about some of the content from the Select Committee, so we'll be interested to see how that changes when it finally comes through. But the Select Committee reported back on the 7th of September, and here we are now in November, still waiting to see the second reading. Some people get quite exercised about the Employment Relations Amendment Bill. Yes, I believe that the trend is in the wrong direction, but I think the fact of the matter is all these changes have very low impact in practice. They really just take us back to where we were pre-2015 because the national government made most of these changes the other way at that time. So if we go through the list, first of all, unions will have a right of access. Now that's heresy to some people, but if you have a unionised environment, this is just nothing of any significance at all. But even now today, unions need your consent, but you can't unreasonably withhold consent, which kind of means they have a right of access anyway. So I don't rate that as a very significant issue. Secondly, unions can initiate bargaining first. But it doesn't matter who goes first. The matter of the subject of the bargaining, that's to say the scope or the coverage clause or whatever, is a matter for negotiation in itself. So it's of no consequence who goes first. 3, employers can't opt out of MECA bargaining. Well, that's a downside for sure, but there isn't that much MECA bargaining. And at the end of the day, if you still don't like the deal, I guess you're not going to be signing up for it. So it's a bit of a sort of a time and cost thing, but philosophically, I don't think it's a very big deal. 4, no ability for the Employment Relations Authority to order bargaining has concluded. So far as I know, the authority hasn't made this kind of decision, or if it has, it might only be on one occasion. And that's because it's such a complicated process to go through to get to that point, because you have to go to mediation, facilitation, and possibly even determination. So it's not a short process. It's not worth the effort. If you think bargaining is over, stop talking about it. No pay deductions for partial strikes. That's a bit unfortunate, but we've lived with that for a long, long time, and I'm pretty sure we're going to be able to get through it again. Reinstatement will become the primary remedy for unjustified dismissal. Now, prior to 2015, this is the way things were, but the courts very rarely awarded reinstatement because they see there's no point once the relationship is destroyed. So I don't think we're going to see too much reinstatement. On the other hand, if the cost awards for unjustified dismissal go up the way they are trending, then sometimes we might want to say reinstatement might be the cheaper option to deal with an issue. So I just think there's a couple of angles on that one. Then there's a couple of issues about passing on information. So we have to give union information to new employees. Well, we have to give them a certain amount of information now. This is just a little bit more. And the process to provide information about new employees to unions is something that we have in part at the moment, but this is just a bit more formal with supposedly a dedicated form to use and that kind of thing. Paid time for union delegates. Well, if you have any sense of unionisation on your workplace now, you'll have some arrangement for a delegate to have paid time to do union business. Then we have an obligation to conclude a collective agreement unless there's a genuine reason not to. Now, that doesn't mean to say you have to agree to anything the union wants. What it does mean is that you need to try hard to reach an agreement unless there's a genuine reason not to. Now, what's a genuine reason? A genuine reason is not that I don't want to have a collective agreement, but a genuine reason could be I don't want to pay $25 an hour. So I don't know any employer that makes a deal they're sort of totally unhappy with, unless they get absolutely screwed, but that's pretty rare. So again, I think most collective bargaining reaches some sort of end point naturally in the end anyway. Next, pay rates must be specified in collective agreements. Well, most collective agreements have pay rates in them. A few don't, but I don't rate that as a great hardship for the vast majority of employers. In terms of new employees again, for the first 30 days, they must be employed on an individual agreement based on the collective agreement if there's one that exists that covers their work. Now, this was the case pre-2015. We got through all that then. Some people seem to think that the way the law is now, they can offer lesser terms to new employees, but that's not true, because if the new employee wants to get the better terms of the collective, all they have to do is join the union and they automatically get the better deal on the collective. So again, I don't think that's a big issue, and after 30 days you can make an agreement on any basis you can mutually agree. Next we have the burning issue for some people anyway of trial periods. These will in future be limited to employers with fewer than 20 employees. And I guess the reason around that is because there's a view that larger employers can afford the HR resources and so on to better manage other options for terminating employees for non-performance. So yes, a retrograde step, but not of huge significance to me. Then we have meal breaks, and I think this is a problem, but you know we will obviously get through it. We're reverting to the 2015 prescriptive approach, which says not only how long the breaks have to be, but when they have to be. And this not going to suit most workplaces. For example, I have some builders working on my house. They have 2 half-hour breaks because they work hard. They need a decent break. A 15-minute doesn't really do it for them. Now, if they were to continue with that under this legislation, that would be unlawful. So I think, like in 2015, unions and employers sort of cooperated to sort of circumvent the law, and I think they're going to do that again. But let's see if that's the way it comes through in the final act. Part 6A will apply to all employers. Now, this is the transfer of undertakings, so it's the sort of activity that goes on where cleaning contractors change and that sort of thing. So again, it will apply to all employers, including the smaller ones, so that's another piece of work for a small employer in that area to deal with. So yes, again, wrong direction, but I think, you know, fairly low impact in practice. The bill as currently drafted, and bear in mind we haven't had the second reading yet, is that certain elements will come into play on royal assent, and some will be 4 months after that date. Now, the ones in the blue here are the ones that come in 4 months after the date of royal assent, so we won't see those in force until, I would say, at least the 1st of April next year. The other ones, they come in more or less straight away. In terms of other changes, the Triangular Employment Bill is the next one off the rank. It's a private member's bill though, it's not government policy necessarily. So the Select Committee is due to report back on 29 November, and we'll just have to wait and see how that goes. But the aim of the bill is to, if you imagine that you have a temp worker working in your business and the person has been there for a long time, then the question is, who is the real employer of that person? Is it the primary employer, the hire agency, or is it you, the secondary employer? Now, this legislation would enable that temp worker to access any collective agreement in your business, as long as it applies to their type of work, and also enable them to join you in any personal grievance action they take against the temp agency. Another potential change affects dependent contractors. I stress there's no legislation yet, but if you look in the Labor Party manifesto, you'll see that their policy is to provide more rights for dependent contractors, and I'm personally a little bit sympathetic to some of this. At the same time, First Union is taking a test case re the employment status of courier drivers. At the present, the status of courier drivers is governed by a court case in 1993, TNT v Cunningham. Now, the question is whether that is still good law or not. What might arise out of this? You know, would the legislation, if it came along, provide for minimum standards? I suspect it would. Would it provide for leave entitlements? Maybe it would. Would it establish a framework for some kind of collective bargaining? I think quite likely it would, because arguably dependent contractors have less power in their situation than employees in another business. So it hasn't happened yet, but it's potentially in the background, and I think that it could well come to pass. I now want to talk about fair pay agreements, and I think whereas most of the theme of this presentation should be about not much to worry about, this is one thing I think you should get exercised about. Now, I think the government sort of read the tea leaves and decided that employers don't like fair pay agreements and what that might amount to, and so they've promised that there will be only 2 in the term of this government. But of course, when you vote next time, you might have to think about what's coming around the corner. Why I say it's a real threat is because potentially the terms of employment in your business could be set by other people without any involvement by you. It's like going back to the old National Award days, not quite 1970s revisited, but something of that nature, where there are various awards that cover certain categories of work, and we don't want to go back there. That's lacks flexibility. The success of businesses in New Zealand at the moment is around their ability to have terms and conditions of employment that relate to their business. Now, we don't even know what this legislation might look like yet because the Bolger work group is still figuring out what the approach should be, so we'll wait for that with bated breath. But I'm just warning you, fair pay agreements is definitely something to get exercised about, in my opinion. Now we turn to the matter of pay equity, and I think this is a just cause, but it's going to involve quite a lot of work for many of us for some of the next few years. As you know, the situation in the aged care and the mental health and education support staff is sort of largely sorted now, but there's a whole lot pending as well. The thing about a pay equity claim is it's different from collective bargaining, so you can raise a claim at any time, whether there's a current collective agreement or not. And if there is an arguable case, then the parties must negotiate an enduring settlement. That's what the words say. This is quite distinct from collective bargaining, though, in the sense that strike action is unlawful, so you don't have to worry about that. But backdating will be a big issue. How far back do we go with this? I think that in most cases that will be limited to the date the claim was first raised. So I'm not saying pay equity is not a good thing, because clearly it is, but it's going to be quite an exercise for many of us in the years ahead. So, the short summary. What I'm saying to you is there certainly will be change, but it's not going to be anywhere near as bad as it's painted, in my opinion. The Employment Relations Bill is the first thing that we will see, and as I've pointed out, I think most of those issues, whilst they're changes of some degree, are not going to amount to very much in practice. If I come back to pay, which is why most of you are here, I guess, certainly there's going to be some changes in this area. Pay equity is going to result in significant increases in some sectors. Most so far have been in the public sector, and I think that in the private sector, ability to pay will be quite a major factor, because we can't just magic money in the private sector. The CPI projection all the way through to 2020 is under 2%. So even though the minimum wage is racking up quite quickly at 7% per annum all the way to 2021, unless everyone gets a 7% increase every year for the next 3 years, which is unlikely, there's going to be some level of compression. So what we're seeing is 7% towards the bottom end, smoothed out a little bit, most other people getting increases of around 3%. What we're seeing in terms of union action is that they are certainly confident of making quite big demands. They move to strike action quite quickly, which means you need to be prepared. And unfortunately, in our observation, most employers have forgotten how to manage risk, because over the last few years there haven't been many strikes, so they haven't had to. But my message is you need to start focusing on that a little bit more. So, like anything in life, it's about confidence. Unions are confident, employers are despondent, but I don't think there's any great reason to be right now as far as employment relations law is concerned. So my message is get on the front foot, be confident and be successful. So that's it for me today. I'm sorry I can't take any questions, but if you go to our website and send me an email, I'll certainly get back to you. Thank you very much.